On behalf of ASCII, I have great pleasure to extend a very warm welcome to all our distinguished invitees. Important event annually, there has been a little gap, understandably because of the COVID. We are restarting the endowment lecture, and I recognize the presence of many notables. Mr. Anjane Reddy Garu has just stepped in. I recognize the presence of many of the very senior officers. Mr. H.A. Dora is here. Mr. Anjane Reddy Garu has walked in. Mr. Apparao, Mr. Yadav, Rajiv Sharma, Dr. Chakravarti. We are very privileged to have this endowment lecture being delivered by Mr. P.S. Ramohan Rao Garu, former Director General of Police and former Governor. It is little presumptuous on my part to introduce Mr. Ramohan Rao Garu. It is like bringing coal to new castle. But this is the task that is given to me and I will shoulder it. Sri Ramohan Rao Garu is a very distinguished police officer who entered service in the year 1956 in Andhra Pradesh, Pada. Very enriched with his service in the field as a very distinguished police officer, in intelligence services, and later in helming public enterprises and taking them to a path of excellence. He had done it all. He conferred many distinctions, including the 1974 President's Police Medal, the Manager of the Year 1983 by the Hyderabad Management Association for his unique contribution as the Vice Chairman and Managing Director of the AP State Road Transport Corporation. He also helmed Alvin, and he had the vision to lay out a privatization plan before it became Navunda soft. He was far seen as a visionary in management. More significantly, after laying down service, he had been the governor of Tamil Nadu, and he was a principal governor and gave principled advice to then who is not a very easy by any reckoning, but he commanded and he held her respect. Dr. Mr. Ramohan Rao Garu is associated with several professional management bodies, including the Confederation of Indian Industry, All India Management Association. Cause of the disabled is close to his heart, and he has been associated with the AP Association for the Mentally Retarded, the AP Center for Emergency Medical Services, Rural Education Institution. I would stop at this point because I could go on. His accomplishments are many, and the time given to me is short. With these few words, I welcome Mr. Ramohan Rao Garu, and now I request the chairman to introduce today's event, the subject, and to give his great pleasure to see so many distinguished personalities. I go nearby. I think maybe year of the Indian Police Service is represented here. So I'm very happy that all of you are here, especially welcome the present DG, and
especially the members of Mr. Venugopal Rao's family. Dr. Mohan Das is here, a very distinguished neurophysician. His wife is here, and Dr. Manimala Sahat is here. Dr. Yes, is here. Her husband, Yasna and Rosarie, the other members of the family, were most welcome. This is an oration in memory of Mr. Venugopal Rao. And very briefly, to mention, Mr. Venugopal Rao joined the police service in 1976, and then he left it quite soon. 49. So, and then he prematurely resigned, prematurely retired in 1976. Then he became a fellow of the Indian Institute of Advanced Studies in Shimla. Then he was given a D.Litt degree by the Andhra University. And he held many posts in the CBI, IB, PCR, and the Bureau of Police Inspector. The point is, he was a thinking man, he was a writer, and he was a researcher. So a thinking, research-oriented, and experimental, policeman. He was this one. So I'm very happy that we are, in his memory, we are conducting this. Last 4 years since we started, we had very distinguished people. Kiran Bedi was the one who started it off, and then many other people, including Justice Palamaikwar. Now, the Ram Mohan Rao Garu is colleague, and he's going to the present status of criminal justice. Some good luck. So the point is, I have been asked to introduce the subject. It's so difficult because it's such a vast subject. It has so many subparts in that. Just mention the investigation part, the prosecution part, then the trial part, and then ultimately the jail part, the prison part also is a part of this. And when we talk about this criminal justice system, what generally happens is, I have been known to tell you that sometimes you ask the police officers what is happening. They say that there are some things to be said, but essentially they talk of something else. Oh, the prosecution, we don't get proper help from the prosecutors. You talk to the prosecutors, they talk to the jail. The judicial system is so confusing and so procedures oriented and all that. So one blames the other. But I always had been saying that let us look at our own selves. In each department, there are eminent people who are interested in improving the system to there. Let us improve our own things, I think that would be a good approach. So, the problem dealing with the police is a state subject. And it's very, the performance of the police varies from state to state. And so how do you generalize and then in a meeting like this, mention something about it? And as I said, the prosecution, the investigation and all that, each has got its own highs and lows. And so the point is, it's very difficult to generalize. Some states have done very well, some states have done very differently. One of the states which has been held up as a model is Kerala, the Kerala Police Act and all that. Now, as far as Telangana and Andhra Pradesh are concerned, they have done excellently in certain areas. For example, in introducing the AI, introducing the digital system. For example, I think it's one of the first states to introduce the automatic chalans for traffic and all that. The camera network, the surveillance network is very good. The cyber crime is quite well. But there are weak areas. For example, in the case of investigations, my own impression is the forensic science, we are not given the necessary importance that is required. The southern states are much better than the north. Tell me, who should head the prosecution branch? Now, there are different directors of prosecutions in all departments, in all states now. But with the police officer, he sort of suddenly there. And he doesn't do police work, sort of independently as a prosecutor. And when does the prosecution advice come to the policeman? It should come simultaneously as the case is submitted, not afterwards. It's filed in the court. That's not the stage. The stage is the advice should be available throughout when the investigation is going on. And I think some reform is required there. Then the trial, the less said, the better. The amount of pendency, you know, is staggering. But the jail system, the under trials in the jail population, was just seeing 79% of the jail population are under trial prisoners. Now, I don't think the system can work, you know. So I hope Ram Mohan Rao will touch some of these things. But the overall general feeling is that the process is much more painful than the punishment, I think, actually, in the entire police thing. So can we ease this, you know, the process being less painful? And some victims to come up, vigilantism. Yes, happily it has come down to an extent, but a lot of vigilantism was there. And then we call ourselves a society which follows the rule of law. I do not know. And then the bulldozing of properties. Now, which law permits that? State. So I think someday we should call this to order, you know. Then some other issues. The police acts have all been amended. It is called in Hindi, what is it called? Bharatiya Nyaya Nigam or whatever it is, all the three acts. But one thing I always was wondering is there are almost about 200 non-cognizable offenses in the police act. Now, the police cannot act on the non-cognizable cases. The cases are registered and they have to direct the man or send a list to the magistrate. If the magistrate orders an inquiry or an investigation, then only investigation takes place. Otherwise, the policeman has no jurisdiction to investigate this case. Now, why do we have so many non-cognizable cases in the law? And why is it put in the police? Because I know some cases where the non-cognizable cases are also sort of, you add one cognizable offense also there, and rope him in somehow to tackle him. Then the police act, as I said, are not updated in many places. I think the worst case is Andhra Pradesh and Telangana. I don't think that changed this. I mean, the title may be the Police Act 1979 or 81 or whatever it is, but if you read the text, it's just the same as the original Police Act of what year is that? Same thing. It continues, you know, most of it. I think it's a time that these things are false. One more thing is, so much of the investigation is being made, and everywhere the investigation is given to the police. Now, even in social legislation, like prohibition of child marriage, covering or Forest Act, Wildlife Act, is it necessary that all these cases must be handled by the police? If they're not handled by their departmental people. For example, the Prevention of Money Laundering Act, the police come at a very, very late stage. In fact, it's investigated by the enforcement of customs cases. Similarly, I remember a case, Bonded Labor Abolition Act. The powers were given to the Tahsildars and other people. There were many acts in the past. Actually, we need to have what are called bench magistrates and all that, deciding some of the cases. I think some social legislation at least should be taken out from the police, you know, so the police can concentrate what is their own job. So, yeah, I think generally I have covered this, and I don't know what areas Mr. Ram Mohan Rao is going to cover, but I'm sure that it will be a very scintillating discussion that is going to take place. So I welcome once again all of you and Mr. Rama Rao in particular. Thank you.
Padmanabhaya, Ramesh Kumar, Dr. Mohan Das, members of the family of late S. Venugopal Rao, distinguished invitees. Lot many of them happen to be, as I see, my colleagues in the Indian Police Service, professors, the faculty of the Staff College of India, Administrative Staff College of India, ladies and gentlemen. At the outset, I would like to convey my sincere thanks to Dr. Mohan Das and other family members of late Venugopal Rao for having extended to me this privilege of delivering the oration in the memory of the Venugopal Rao. I also, in this context, thank Padmanabhaya for endorsing the decision of the family to invite me to this lecture. I think it will be appropriate if I pay my homage and tribute to the memory of the Venugopal Rao. I would like to let you into a small anecdote. The Venugopal Rao was the superintendent of police in Guntur district in somewhere around 54, 55, 55, and 56 also. And my first posting in the Indian Police Service happened to be as Nurser Office, a part of Guntur district, as the assistant superintendent of police in charge of Nurser Office, very vast and sprawling division with I think 17 or 18 police stations. We have at least half a dozen murders every month in those days. A place. So, you know, one of the important responsibilities of a sub-divisional police officer is to inspect all the police stations in the jurisdiction every year. So he had to inspect 17, 18 police stations every year. And the instruction from the chief office, which is the office of the Inspector General of Police, were that you should conduct an inspection for 3 days. You should spend at least 2 nights in each police station when you do an inspection. So 18 into 3, 54 days, plus travel up and down. Almost 2.5 months, 3 months of our time was spent only in inspection. So whenever I went to the as initially, so what I did in my first inspection was, I said, how do you do an inspection? I had some idea of how to inspect police stations because we were taught that during our practical training. Nevertheless, I thought, let me see what my predecessors wrote on this police station. So I asked the station house officer, I said, bring the inspection register, inspection note register. to the inspection bungalow. So I used to go in the evening so that I could commence my inspection the next morning. So that night I used to go through the past inspection. And I had many distinguished predecessors in Mercer office, sub-divisional predecessors. One of them was Shankaran Nair. I don't know how many of you have heard of Shankaran Nair. He retired as the director of R&AW, and later on he was also Indian High Commissioner in Singapore. One of the illustrious IC officers. His inspection notes struck me as modest. He used to write in his own hand, 9-page, 10-page inspection. Probably typewriters were not provided to the sub-divisions in those days. But more than Shankaran Nair, the inspection notes of Venugopal Rao as the superintendent of police were absolute model. If you read his inspection note, you knew everything about that sub-division, that police station. The past crime, who are the main criminal gangs operating in that area, which are the important patches, villages, etc., etc. As we say, the sun gets dried up every 5-6 minutes. No, it's better. That's not that convenient. Therefore, I started reading his inspection notes whichever police station I went. And I used to find them extremely illuminating. You know about, there's a place called Gurudala, one of the highly factious villages. And it said the Gurudala, the circle had about 5 police stations, 7 police stations. So when I was looking at these inspection notes, I found certain criminal gangs operating in that. And then when I went next morning to inspect the police station, I found a series of professional housebreakings were not detected. They were lying undetected for months, 3 months, 4 months, 5 months. So the previous night I read that inspection register, and Venugopal Rao inspection note. And he mentioned a couple of criminal gangs. So I asked the station house officer, I said, look, are these fellows KD? KDs are known depredators. We open a cease on every KD and maintain a watch on it. So I looked at that, and these chaps, 3-4 fellows mentioned, I know their names, but not me. Even today I remember the names because that made my name in the police. So I said that, look, bring the KD sheets of these guys. It's not, they were out of me. So I said, all right, next police station, some offenses attributed to. In all about, there were 2 gangs, I think in all about 18, 19 offenses. One modus operandi was roof hole. You make a hole in the roof, those houses in Palnad and Rayalaseema, you could make a roof hole and get into it. And the other set was all robberies. Robberies was a particular modus operandi. And these 2 KDs were the chaps who were the gang leaders of. So I constituted a special party. We call them the detective party. So I pulled out a sub-inspector who didn't have very good reputation as a sub-inspector. So I called him and said, look, I said, this is your best chance to make amends and improve your career prospects. If you get me these cases, your stock will go up, my stock will also. So, and I gave him a few head constables and constables. And lo and behold, we traced all the 18 cases, 19 cases, and got these guys along with their compatriots. And about 15 days later, the IG happened to come to Guntur. And Mr. Nambia was a taskmaster. Though ultimately it didn't end well, his career, but he was one of the most brilliant police officers India has ever had. Not very much recognized because of his other handicaps. So he used to take a crime review. So in the crime review, I got up and said, sir, this is what we have done. He was so pleased that, as I said, I made my career after that. So even today, if I have reached where I am beholden to Venugopal. And I've recorded this in my memoir also. The mention of Venugopal Rao is there. I told Mohandas long years ago about this, so he knows that. Perhaps that's one reason you have called me up to deliver the lecture, this oration. He was a many splendid personality. You know, most of you may not be aware, you know, those who came of age, went out of universities between 1941 or 40, 41, 42 and 47 were not very lucky people. Because of the war, World War II, recruitment to the Indian civil service and Indian police was stopped for about 4 or 5 years. I think the last batch of ICS and IP was 43. And the first batch of IAS and IPS was 48. For 5 years, there was no recruiting. Venugopal Rao belonged to that generation. Otherwise, I'm quite sure he would have been in the ICS. If not in the ICS, at least he would have been in the Indian police. Anyway, he came into the Indian police. But he was more than a policeman. There were many faceted personalities. He was a great penman. And as a penman, not only did he write tracts about police, criminology, crime and all that, he was a very good storyteller. And he wrote a lot of short stories in Telugu, which were published. And I think obtained for him a D-List from Andhra University. And more than that, he had a great sense of humor. Though a little bit sardonic. He was not a full-throated humorist, very sardonical humor, but he was a great humorist. And we used to enjoy his humor in those days. See, 3 or 4 of these officers, Venugopal Rao, Victor, Ramchandra Reddy, they were a great bunch of friends. Whenever we came from district to Hyderabad, we invariably spent some time with each one of them, half an hour to 40 minutes, and learned a great deal of policing and other matters from these 4 or 5 officers. So that was Venugopal Rao. And apart from being beholden to Mohandas for giving me this opportunity, I think it's a great thing to recollect some of the memories of Venugopal Rao on this unique occasion. Now I come to the topic of the day. Now when Professor O.P. Singh asked me what I would like to talk on, I didn't quite know what I should talk on. And then it suddenly occurred to me that only a couple of months earlier, the new act, the new legislation replacing the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act came into force. Because we had done a lot of work on this earlier, before they came into force. Then it suddenly occurred to me, why not in this context, why not I talk a little on the state of criminal justice system in India. Now, you may all be expecting this oration to be a very erudite, high-level, philosophical lecture on criminal justice and the principles of criminal justice, the jurisprudence behind it, and all that. But I would, if you are expecting that, I would rather disappoint you for expecting such a high-level oration. And as Padmanabhai has said, it's a very vast subject. You had, criminal justice consists of 3-4 facets. You have the investigation, you have the prosecution, you have the trial, and then you have the appeal on the outcome of the trial. So it's a 4-stage system where each phase is controlled by one particular department of the government. But when I talk now on the state of criminal justice system in India, I want to sort of come down to earth, to the ground realities, take you down also to the ground realities, instead of giving generalities and principles like that. I would like to take you down to the ground realities of the situation and the very terrible, perilous state of criminal justice in India, which I do not want to bore you with a lot of data and statistics, but I would like to mention one figure. Today, as of, I think, August 2024, the figures are not very reliable. We just checked up some figures with the help of one of my colleagues, Damodar, is here. And I find the various kinds of figures, there he is, various kinds of figures furnished, and you cannot really rely on many of these figures. But it is enough to say that as of August, both civil and criminal cases, 51 point and odd million cases are pending trial. Trial court in the appellate court and in the top 51.4 million. And the figure suggests that almost 80% of these cases are criminal cases, which would mean 40 million cases are pending trial. And the figures also indicate that only about less than 1 lakh of cases are pending in the appellate court. That is, when you go appeal to the district judge or the high court or the Supreme. If you omit that 1 lakh from 40 million, still it is 40 million. So 40 million cases are pending trial in the trial court. That is the enormity of the state of criminal justice in India today. Now, if you don't try a case and deliver a verdict, you cannot really dispense criminal justice. There's no Another interesting figure that came out in this examination of the data is that if 80% of the cases are criminal and 20% of the cases are civil, the total pendency. In the allocation of resources, have the judiciary allocated 80% of the magistrates and the judges to criminal cases and 20% to the civil case. So if you don't allocate 80% of the physical resources to the criminal case, may not be 80% because criminal cases are rather simple. Civil cases are much more complicated. Even say 60% or 65% of the physical resources, if they are not allotted to disposing of the criminal cases, then you will find the pendency growing every year up. And there again, there is an interesting figure that of the cases instituted in every year, only 60% of them are disposed within that year.
So 40% spill over to the next year. So the next year you have 140. 80 of 140 will be about 120. So the tendency keeps on increasing. There is no way the tendency. And if you don't deliver justice, you can't maintain order. You can't maintain the rule of law. Therefore, my lecture today is principally directed towards that part of criminal justice which is in the trial court. You may say, well, you're an IPS officer, therefore you will now belabor the judiciary in charge of the criminal cases and you will exonerate the police. Not my intention to do so. The police role in trial cases, the police role in ensuring the rule of law is altogether a different subject. I think probably that requires another oration by somebody else who knows the subject. But the short point I would like to make in that regard is that, our police administration is all inspection oriented. The hub of policing is the police station. So you have a station house officer. And that police station is part of a circle. So you have a circle officer. And a few circles are supervised by an SDPO, that is an ASP or a. And over the SDPOs, you have the district SP. And over the district SP, you have the range DI or the range I. So except the SHO, and to some extent the superintendent of police, all the others in the hierarchy are inspecting officers. So a circle inspector visits all the police stations in a jurisdiction every month and reviews the cases pending investigation and pending trial. The sub-divisional police officer does a detailed inspection of the police station every year. The superintendent of police does about 1/4 or 1/3 of the police stations in the district. Detailed inspection. He also stays 3 days, 3 nights in that. He does. And the range DIG over and above the SP, he also does. So you will seldom find cases pending investigation in a police station for more than a year. So these cases go to court. So that's why I don't want to touch the police aspect of it. So I now come to this trial and what is happening on the ground. Most of you are not aware of what is happening in the ground. And when we talk on the lofty principles of justice, dispensation of justice, jurisprudence, the philosophical underpinnings, the fundamental rights, etc., we don't understand what is happening on the ground at the police station and in the trial stage. So I would therefore try to confine my oration to the trial court. I wouldn't like to go beyond the High Court or the Civil Court. Now, in the trial court, there are 4 phases. Now, the police investigate cases and they subject them to the scrutiny of the prosecutor. We have prosecutors for every 2 courts, 3 courts. In fact, we should have a prosecutor for every court, strictly speaking. So we have what they are called assistant public prosecutors, grade 1, grade 2. So these cases are sent up to them. They look into the charge sheet. Actually, charge sheet is a final report. It's where it is, the proposal is to try the accused in the case. It is called a charge. If it is not, it is called a final report. So this draft charge sheet is vetted by the prosecutor. And then it is filed in the court. So I am not touching those pages. I am coming straight away to the trial court. So in the trial court, there are 4 facets. One is management of the cases. What the judiciary calls case management. How
cases are managed, how they are called for trial and how they are heard. The second one is the actual procedure of trials. Procedure of trial. The third one is, I would like to call systemic bias. This is very often not understood even by police officers, much less by the public. And the fourth one is, of course, appeal. Now, in the present arrangement in the country as a whole, we have at the trial level what are known as municipal magistrates. The municipal magistrates trial, they try both civil cases and criminal. Now, that is one of the major handicaps in the criminal justice dispensation. Then the municipal magistrate have jurisdiction over, say, a circle inspector's jurisdiction. Circle inspector. Trust me. That would mean about 6 police stations or 7 police stations. Now, what happens is, there is no classification of cases on the basis of their date of filing of the charge sheet, or on the gravity of the case, or on the otherwise importance of the case. So the magistrate posts 2 cases of police station A, 2 cases of police station B, 2 cases of police station C, 2 cases of, like that. There are 5 police stations, probably 10 or 12 or 15 cases. He posts for a trial, on a particular. Now, in 1955, the Criminal Procedure Code, which has been repealed by the new Act, was amended for the first time after independence. And one of the things that they did was, earlier to that, the magistrate had to issue summons to the witnesses. So the witness, that process would be served by the police station on the witness. So bind the witness to come to the court. They did away with that. They said it is the responsibility of the station house officer to bring the witnesses to the court. Therefore, there is no summons. So there is no proof that the man has been called to court. Now the magistrate has posted 6 or 7 cases, and in each case, suppose the station, and then they belong to 6, 7 different stations. And the station officer decides, all right, these 2 cases, I will take the witnesses. He will take 2 witnesses in each case. He will send a chap to the villagers, bring them to the police station at his cost. The government doesn't give anything for them. Then the fellow has to be fed. The witnesses have to be fed. And then they are taken to the court. And what happens in the court? And all my colleagues here will bear me out. And even today, that is the situation. The magistrate works for about 6 hours, whole day. Until lunchtime, he does what is known as call work. The call work is whether this particular case which he has posted, whether witnesses have come or not. So in this process, the forenoon is gone. So 1:30 adjourns for lunch. He comes back at 2:30. And he winds up his court work at 4:30. He works 2 hours to actual recording of evidence in cases. And it is not necessary that he only hears all criminal cases on each day. He does also the civil case. So you really do not know how many witnesses he will be able to record on a particular day. So what happens? Suppose a station of 6 cases, 6 into 2 or 12, 13 witnesses have been brought. at the expense of the station house officer. This fellow closes his proceedings at 4:30, and then he writes on the docket. He would have examined one or two witnesses. The remaining cases adjourned for non-production of witnesses. This is what happened. Now, how many of you, other than police, not many police officers may realize this. This is what exactly happens in a court. Non-production of witnesses is a falsehood. And why does he do that? If he says that witnesses are present and adjourn the case for want of time, he'll have to pay bata to those fellows. So now, if he says non-production of witnesses, there is no need to pay him for bata. For all the expenses devolve on the poor station house officers. And you will be surprised that most station house officers collect money. 100% collect money from, shop, this, that, and that. Many people think they are very corrupt. Most of them are poor. Most of the money collected is to defray the expenses of this time. In a police station, our days, in fact, I'll tell you, when I was the Director General of Police, I proposed that each police station should be given a lump sum amount per month as sundry expenditure, so that he will meet his expenses like this without having to beg the shops and what have you. Of course, it didn't come through my time, but the previous government, as soon as they came to power, in Telangana, they gave to each police station, depending on the grade of the police station, about 25,000 to 100,000 rupees per month. So that is the kind of expenditure that the police station incurs on these miscellaneous varieties. So that, you can minimize corruption. So this is, case management is so poor in magistrate court that pendency grows year after year. So you will hardly see, you go to any police station even today, I check, you will hardly see any case pending investigation for more than a year. Probably maybe one or two which are dependent on documentation, and you require a lot of, like cooperative societies misappropriate. Misappropriate cooperative society common. But you require the audit report. And the audit report may take a long time in coming, and therefore the case may be delayed. Except for cases of that nature, you will not find cases pending investigation for more than a year. That is why I have left out the police part of it and the prosecution part. The second one relates to procedure. This is the bugbear, real bugbear. The first one is bad enough. This is worse. That police are very happy arresting accused and putting them in prison. That is not acceptable. In fact, Justice Malima, 20 years ago, produced a report, and few of us like me, Anjaney Reddy and Ved Marwa, who was, Commissioner of Delhi Police, later he was Governor, was my batchmate. We all made a set of recommendations. We said that we are not interested in arrest. Instead of classifying cases as cognizable, non-cognizable, classify them as arrestable, non-arrestable, and make the bulk of cases non-arrest. And in fact, for good investigation, arrest is the least important. In a murder case, if you arrest the accused, the murder accused, the next day, your case is gone. Because you will have to produce the documents to the court by that date, and your documents will all be in hell, sort of helter-skelter, full of inconsistencies, and surely you will be thrown out in the court. So we have made a lot of recommendations. Many of us have accepted them, but they have not been implemented. They have not been accepted by the government. Anyway, that's another thing. So, appearance of the accused. the first part of the crime. Now the accused goes on bail. He would have been released on bail. And he has to appear on court. And he will not appear on the date of hearing which has been posted. The case is adjourned. And you will be shocked to know that for appearance of accused alone, cases are adjourned anywhere between a dozen and a few dozen times. Even if it is a rate each person, which is for appearance. Now, this is another major cause of tendency of relationship. The next part of it is, if suppose there are 6 accused in a case. Now, the case trial won't start unless all the 6 accused appear in court. Now, what they do, 2 fellows appear, the other 4 absent themselves. So, for production of those 4, the case is adjourned. So, next time, 3 fellows appear, adjourned. Then 4 appear. Then after the 5th adjournment, the first 2 who have been appearing every time, they don't appear. So this becomes a kind of, the cocoa kind of play among these accused fellows. So appearance of the accused is the next case there you will find. Cases adjourned for dozens of times a year. And you will be surprised to know when we prosecuted the extremist, CPI Maoist group, the famous Nagareddy case. And after that, we had the Parvatipuram conspiracy case. And then the 3rd case was the Revolutionary Writers Conspiracy. We had 3 famous cases. In the Nagareddy case, the trial was completed in about 3 months because this was a concentrated trial. And they were all in jail, including Nagareddy, principal agent. And you'll be surprised to know that Nagareddy, they were all convicted. Nagareddy, in the open court, he praised the prosecuting, the investigating officer for the website. That was the kind of investigation he had done. But when it came to Parvatipuram case, it took almost 10 years. In fact, the case was instituted in 1969. And this was finally acquitted in the AP High Court by a justice in 1981. All the accused were released. And of course, I don't want to go into that. But one of the example I can give you, one ground on which he was acquitted was, they were acquitted was, the diaries of these accused were produced. So I think, was it Nagabhushanam or Patnaik or somebody? In his diary, he noted, met KS. He wrote met KS. Now, in the context of that case, KS was Kanu Sanyal. Kanu Sanyal belonged to Bengal. He was one of the foremost Maoist leaders. He also had Kondapalli Sitaram. Yeah. So the judge said, case doesn't mean anything, whether it is Kanu Sanyal or Kondapalli Sitaram. That's wrong with you. Without sort of relating it to the context that it could only be Kanu Sanyal and not. So like that anyway, that is the other part of it. So in these cases, there were 20, 30 accused and 15 of them were underground. And we could not produce them. Giving you an example, illustration. They were not able to produce these fellows who were underground. So at some stage of the case, the prosecution petitioned for listing the case. That is, you split the case against those presenting themselves in court, take the rest out. So that was done. I'm telling you of the criminal procedure code, the pitfalls of the criminal procedure code. So when the case was proceeded with these fellows appearing in court, and a couple of or 3 or 4 witnesses were examined, the fellows who were appearing in court went underground. And a couple of underground chaps appeared in court and said, recall the witness. First, there is rejoining of the trial. So the trial has to be rejoined. And after rejoining the trial, the witnesses already examined will have to be recalled because these people were not present when they were examined. And you know, no 2 versions will be the same. And there will be a lot of variations on that. The witnesses' integrity and veracity of question and the so on. Now, this is the kind of procedure code that we have got. Then I come to the systemic bias. The systemic bias is not appreciated even by us, by police officers. Now, the systemic bias is, you know, unlike the civil cases, in civil cases, there are 2 parties. 2 private parties it could be. It could also be a state versus a private party. Basically, there are 2 parties. But in criminal cases, you have the investigation, the prosecution, and the judge, the trial judge. There are 3. And the municipal magistrate or the district judge who tries these cases, he has invariably come from the bar. And when he has come from the bar, and when he is recruited to the judicial service, he would need a minimum years of service at the bar, practice at the bar. And at the bar, he only defended accused. He never prosecuted accused. Therefore, his entire mental orientation is a defense orientation and not a prosecution. So this is thing which is not appreciated by most people, even within the police. Then what happens? You know, not many of you are aware, maybe, in the Criminal Procedure Code, if a case is acquitted, an appeal lies only to the High Court. Doesn't lie to the session. And High Court very rarely admit appeals against acquittal. And the 2 principles involved in deciding whether they could be admitted or not are, if there is very serious miscarriage of justice, which cannot be proved. And the other one is if there is a serious point of law involved. And in trial cases, there is hardly a serious point of law. So no acquittal, very seldom, probably 2 out of 100 may go to appeal in High Court. But if a man is convicted, he has the right of appeal to the Sessions Court, to the High Court and the Supreme Court. For if a municipal magistrate convicts a person, his judgment is subject to the scrutiny of the district judge, of the High Court, of the Supreme Court. If he acquits, his judgment is not subject to any scrutiny. So the balance of convenience for a municipal magistrate is to throw out this. However good the case is done. This is a bias which is inbuilt into the system, which is not appreciated by even police officers. So this goes on, and so there is no appeal against acquittal. So you throw out the cases. And if you throw out the cases, well, it impinges on the rule of law. So these are some of the illustrations that I thought I would make in the course of this lecture. I didn't want to touch on the jurisprudence and all that to sort of analyze the very poor state of criminal justice in India. And these are the reasons why we have millions of cases pending in trial court, and they will never see the light of day. In fact, when I was Director General of Police of the state, I had, the other point, in this context, I'll tell you. So I was Director General of Police of the state. I looked at all this and I decided something should be done. Now, Padmanabhaya has brought up the issue that we have now directors of prosecution in each state. These are new posts that have been created, probably in the 80s or so. Now, what have they done? Most states, they appoint police officers as the director of prosecution, which is a very, very wrong thing. It's an absurd thing. So I had not chosen that route. I wanted a district judge as the director of prosecution. And I wanted a district judge for 3 or 4 reasons. Now, a district judge will be better able to coordinate with the sessions judges in the district. A Director General of Police or an Inspector General of Police appointed as Director of Director of Prosecution, he will not have the same kind of bond harmony and relationship with the sessions judge. Apart from the fact that he will think, why should I call on a district? You know, the egos also start playing a big role. So I had an young sessions judge and I proposed 3 or 4 things. I'm illustrating this because solutions also I'm telling you. And I wanted the district judge not merely to coordinate and liaise with the session judges, but also with the chief justice of the High Court. For every proposal that I had for reform, the prosecutor will take it to the chief justice, discuss with him, and only after his approval, we would introduce the rest. So I wanted 3 or 4 reforms. One was that the case management has to be improved. So post the cases of a police station only on one day in a week, so that the station officer will know that on that day he has court work and he will pay attention. If you post his cases, 2 cases today, 2 cases tomorrow, 2 cases on Friday, 2 cases on Saturday. Now he can't be going to court every day. Station officer has so many multivarious functions. So he will not be able to devote his time. So magistrate to post cases of each police station on a particular appointed date of the day of the week. So different police stations will have different days of the week. And they know Friday is my court day and I will pay enough attention. Then I also wanted the Chief Justice's permission to withdraw the prosecution of all cases which have been pending for more than, except the grave offense. Because if a case is pending for 3 years, the sub-inspector who has investigated the case would have left that police station. The new sub-inspector will be worried about his cases, not about his predecessor's case. So like that, there is no point in keeping these cases on the roll and then wasting the time of not merely the police station, but all the magistrates. So I said, I will withdraw all cases which are pending for more than 3 years. And I had also instructed all my SPs to review all the cases and decide on which cases we should have to withdraw. Then the third thing was I wanted reforms in the prosecution branch. And I made the director of prosecution to visit all the districts and sit in the sessions court and hear and watch the trials of some of the sessions cases to let us know how the policemen are faring in the investigation case. Like this, a set of reforms we had started, and unfortunately I left midway and the proposals were never carried through. The one proposal that was carried through was this station houses getting this miscellaneous section, and that was done when Secretary of the first Chief Secretary of Telangana government. Now I can go on and on with reference to the High Court and the Supreme Court, but basically these are the problems, and unfortunately I don't know for what reason, Justice Malimat committee looked into all these issues. In fact, I had submitted a long memorandum to Justice Malimat before I became governor. And Malimat, in fact, about 40% of his recommendations related to my proposal. Some of these things. But these things about withdrawal of cases, he said, no, we can't withdraw the case once it is taken up on the docket. So, but he had accepted many of these. And one of the most important reforms that Malimat has briefly touched and then closed my remark. And that is, see, if by a different accident of history, if duplex conquered India instead of slide, we would have had a different system of criminal justice. See, what we have in India is the British system, which is adversarial. And in the adversarial system of justice, there is no responsibility for the judge to seek truth. All that he has to do is sit in his chair, judge's chair, and ask the prosecution to prove that the person accused is guilty. And the standard of proof that is required is beyond the shadow of all reasonable doubt of an ordinary prudent person. Now look at the definition of the standard of proof. Now, every case can be thrown out on this standard. Every case can be thrown out on this standard. And if we had only the European system, which is called the inquisitorial system, then the judge has a role to seek the truth. Who exactly committed the offense? This is not the person. So things would have been different. And Malimat, I had made the recommendation, saying that if we propose that overnight we should replace the adversarial with the inquisitorial, no government will agree. So I said, we will marry the two. If a prima facie case is made out, we should skip from adversarial to inquisitorial, so that the judge comes into play and we have better rates of complaint. And it was recommended by Malimat, but it was not accepted. In fact, his report is on the shelf. And what is sad is that Malimat committee was appointed by a BJP government, by Vajpayee's government. And this government, strangely, did not look into the Malimat committee report, did not consult the police, did not consult the prosecution. They consulted a few vice chancellors who were academics. And I think these people have amended these 3 acts. And these 3 acts are the old acts put in new titles. Not even format. The sections changed. Numbers of sections have been changed. They've been put into new titles. And nothing has changed. And I'm sure if after another 5 years we will find that the pendency will be not 40 million, probably it will be 50 million. So on this note, thank you once again to Padmanabhaya and Mohan Das for giving me this opportunity. I didn't want to give you a theoretical oration. I wanted to bring you down to the earth and tell you what exactly is happening on the ground. And this is exactly the state of affairs. Thank you very much.
It's a very insightful presentation. I'm Dr. Pratibha Ganeshan from Urban Governance and I'm a faculty here. Sir, I have been looking into the sanitation workers' deaths for some time now. So in the last 10 years after the Manual Scavenging Act has come into picture, there are somewhere around 656 deaths that have happened. And then when I looked into some of the literature, there has been not one single conviction that has happened based on that act. And also, whenever the judgments or anything that comes, there's a lot of confusion in defining the whether the technologies, for example, septic tanks or sewer lines, and who is who is responsible for all of those things. So there is a lot of confusion that is there, even in the explanation of this.
Sorry to interrupt. Please ask your question. Don't
Yes,
make a statement.
No, I'm coming to
No,
my
it is-
question. So I need an advice actually.
That's the sanitation workers. Now, sanitation workers are prosecuted?
No.
No, they die because of
Yeah.
smoking,
Yes.
because of the pollution. Yeah.
So
So
initially,
who are prosecuted?
so mostly
Public-
sometimes contractors who are actually employing them are under the prosecution. But I want an advice, it's not even a question. I was thinking that maybe we should provide some capacity building or something for the people in the legal system, because whenever the conversations are there, there's a lot of confusion that is there. So, but after hearing your story, I'm like, where do we start and what do we do on that? If you have any advice on that, it would be.
Yeah. The capacity building is good. So there is no confusion on it. In fact, it's also, I had one more proposal. And that proposal is to correct this systemic bias. All people who are session judges, they should be also put through police training. They should be put in charge of a police station for 3 months and asked to investigate a couple of cases. Then they will realize how difficult it is to investigate a case. In fact, this was implemented. Anjanaya Reddy will bear me out. When we started the police academy, municipal magistrates were coming to us. But I am told that it has been dispensed with staff. I don't know, Anjanaya will insist. He's not there. So stop. And in that context, it suddenly occurred to me, and I find a new phrase that in India, it is no longer law and order. It is law against order. Oh, you go on amending law in a manner that it makes enforcement of order very difficult. Impossible.
I feel that a police station in India, especially in the suburban and the rural area, they are the actual face of the administration.
Yes.
Anything to do, people rush there. And really, I bow my head to the people who are involved. But with urban experience, we find that all sorts of things, bandobast, tragedies, flood, drought, anything happening to the society is the police station, which is at the cutting edge. Where is the time for prosecution and evidence gathering and what we said, trial, court, etc.? So why can't we have dedicated people for trial? I am done.
That's true. That's true, but there is no other way. In fact, the police station is the only one not closed. It works permanently through night and day. The general diary is the one document which is never shut. It is all open. But see, the point is they have overworked. They have, in fact, the Indian Police Act lays down all these duties. Bandobast duties and all. So they are overworked, understaffed, and the judiciary complains of poor physical infrastructure of the courts. You must go and see police stations, how bad they are. So that is another part that the police stations, suffer from. Oh, you're very right. I quite agree with you.
May I request Dr. Mohandas to present the bouquet to the very distinguished guest and speaker of the day. May I request our chairman to present the memento to that. Please, sir. Coming to an end, we are sufficiently enlightened, sir, and seriously disturbed at the state of affairs. You gave so much thought to ponder and to apply our mind. These solutions are not easy. But nobody could have stated the problem more lucidly than you did in your vast experience and wisdom. And thank you for a very stimulating and a very, as I said, a very disturbing lecture. Thank you very much, sir. Thank you. One more minute, a vote of thanks by the family.
Sorry, you will all have to sit down again. I won't take too much time. Already I have to stand up and sit down again. Yeah, I just like to, thank everybody here who has come in today. Of course, for the ASCI for supporting all of this. Mr. Padmanabhan, thank you so much for giving us some insights into what laws we are following and when they were written. And it is quite interesting to hear those. Of course, a big thank you to Mr. Raman Rao Garu. While for us, people outside of the system, it was quite scary. But I think some solutions and we look forward hopefully for the future. I think today I'm here representing as the grandson of S. Venugopal Rao. And I've heard some anecdotes. I think some stories I have not known before. So thank you for those. I think we'll remember them. For me, I guess, and I try to kind of make a note of a few things. I think for me, I'm one of the 8 grandchildren that he had. I am probably mentioned in few of his stories, and along with my brother. But I think the thing I bring unique to the table is I didn't read too many of his stories. My brother did read. I'm not. At that time, I felt those stories were well beyond my comprehension, and I didn't end up reading them. What I had was real life experience and things to learn, and I got that really from observing him. Right? And there were a lot of people, names were mentioned, people who used to come home. He's a big aficionado of bridge. So a lot of people used to come and play bridge at our house. And there were lots of discussions we used to have with them. And a lot of them were around the criminal justice system. But interestingly, in the next morning, with the same power with which he discussed all the problems with the criminal justice system, he would have equal discussions with our Mali on the garden and the plants that were growing there with equal amount of respect, right? And that's something that we learned as kids very early. And we talk about social justice, racial justice, but he taught us that, whether it was a Mali or whether it was a senior or a colleague, how to deal with them equally. And that's a lesson, that we take today, even today, ourselves. The other thing I think I fondly remember is he had a fair temper, I would say. I've been receiving end of a few times where he got quite angry with me. And as kids, I think that could have put us off. It could have scared us a little bit. But at the same time, in the evening, we would sit down and watch Tom and Jerry, and you would be like rolling on the floor and laughing. And then you would see these two contrasting sides to him. Like you said, he had a sense of humor, and he would be able to manage those two so beautifully. And that's where we realize that, there's a carrot and a stick, and you need to balance those. You need to be able to mingle with kids who are 10 years old, but also talk to people who are 50, 60, 70 years old. And that's another lesson I think we took, when from him as children. Right? Just finally, I think a couple of words about him. He raised two doctors, he raised one engineer, and he raised one army man. None of them went into the profession that he was in. In some ways, he taught them all some lessons. I see those in my parents, in my uncles, aunts today. I would just say that, even though he was a giant of a man, he cast a very, very little of a shadow, and he allowed everybody to grow in their own ways. And I thank you all for making this a great day for us to, remember him. Thank you so much.